May it please the court. Counsel, my name is F. David Eastman, and I am the attorney for the appellant Damian Seats. Damian Seats committed first-degree murder when he was 17 years old. He was sentenced under the law in this state to what the court had to sentence him to, life without the possibility of parole. After that, of course, the U.S. Supreme Court handed down the Miller case, which required a hearing, found it unconstitutional without a hearing to sentence a juvenile to that kind of a sentence. In between Mr. Seats filing his motion for that hearing and getting it, the governor of this state commuted the sentence of 38 individuals. Excuse me, I'm fighting a cold. 38 individuals in this state to life with no parole for 60 years. Mr. Seats then had his evidentiary hearing, and he testified with regard to his background in particular, the horrible life that he'd had up to that point. The government offered no evidence at that particular hearing, and then the court reinstated his life without parole and reinstated the governor's commutation. You know, I've tried in my practice to apply common sense to the things that I do, because I've found that when I go to research, if common sense is there.
Under the Supreme Court decision, though, after they have an individualized hearing, isn't it possible for a judge to sentence a juvenile offender for life in prison without parole if the judge thinks that's the proper sentence?
Under the current state of the law, no.
You don't think Miller allows that?
I do think Miller allows that. I think that's wrong. I think given that the whole line of cases leading up to it is contradictory to that. The whole line of, in fact, actually, I think Justice Cady said it better and best in a quote from Lyle, and I think the quote came from the Graham case, and I'll paraphrase, but basically those things that make kids different from adults in these cases are not crime specific. In other words, the fact that we're talking about a different crime here from the other types of crimes shouldn't make a difference. I'm asking this court to hold that it's cruel and unusual punishment for any kid to be sentenced to life without the possibility of parole.
Well, isn't there another argument too, and that is that under Miller, as I read Miller, I mean, Miller reserved the categorical argument that you just raised, that you never have life without prison or life without parole for juveniles. Reserved that, but said in any event, if you follow through with a so-called Miller hearing, it ought to be only on rare occasions, to use the language of Justice Kagan, where life imprisonment was imposed. She doesn't elaborate what rare meant. So isn't there an alternate argument that says, well, if there is life without possibility of parole, it ought to occur only in rare cases, and this isn't one of them?
Well, and that's a separate issue from whether or not it categorically would be restricted. Then we have to talk about Mr. Seats' case in particular and whether or not this is one of those rare cases.
As I read I read two things. One, as I understand it, you say that you make a categorical challenge based on U.S. and Iowa Constitution. But then on the as-applied challenge, as I read it, are you saying that the Miller and factors and Null-Pearson factors were not properly applied by the district court?
That's exactly what I'm saying.
Point to me something, because in reading the sentencing hearing, the resentencing hearing, can you point to me something where you think the district court erred in terms of what the district court procedurally was doing on this resentencing?
Absolutely. Give me a second to find. There are a number of things that the courts have been told are things that they need to look at. Age, okay? In this case, the court looked at age. The
court did account for that and noted that I think he was 17 and 7 months, something like that.
Immaturity, which, that's really a subjective thing. Impetuosity, failure to appreciate risks and consequences, family at home environment, which in this case, as I said, was just absolutely horrific, circumstances of the offense, family and peer pressure, inability to deal with police and prosecutors or to assist their own attorney, and most importantly, the possibility of rehabilitation. The court in this case, as I said, considered age, considered criminal background, considered his failures previously with regard to rehabilitation and the facts of the crime. But the court acknowledged that his bleak and desperate life was not an attendant circumstance, okay, of youth that outweighed the seriousness of the crime. But yet, it is an attendant circumstance. Without question, it was an attendant circumstance, and if you take and look at that bleak history and apply it to these other things that the court's supposed to look at, the court does not consider the defendant's gang training with regard...
Your argument is not so much procedurally that the district court didn't consider that Miller-Null factor, but it's that the court should substantively reach a different outcome after considering that factor. Is that what you're saying?
It is and it isn't. Substantively, obviously, I think they should have reached a different outcome by applying the facts, but I don't think they did a complete job of applying it. Because, for example, the gang-related activities that he was involved in, you know, one of the things they have to look at is peer pressure. Well, where does peer pressure come from? Gangs are tremendous peer pressure, but there's no discussion of that in the decision. The effect of having no real parental guidance. How does that affect his impetuosity, his inability to see long-range circumstances that would affect his life without parental guidance? He was on his own from age 16 without any parental guidance. Nothing in the court's decision applied the facts together to the things that the court needed to look at. The court did some of it.
Yeah, the court says what it says. But in Miller, Justice Kagan, as I say, comes just short of the categorical challenge and then says, well, perhaps in some rare cases, to use her language, I mean, rare cases, you can have life without possibility of parole. How do you construe that term, rare? What do you think that means? Apparently, you think it should apply in this case, or that this is not one of those rare cases. But as you read Miller, there's not a lot of elaboration of what it means. What do you think it means?
What I think it means is those rare cases that are so heinous that nobody could conceive of the person being rehabilitated. And I come back to rehabilitation as being the key to determining what's rare and what isn't. Granted, that's only one of the considerations for these hearings, but that's where it comes back to, in my opinion, because what we're trying to decide is whether or not at some point in time these kids would be rehabilitated to the point where they could be put back into society as productive citizens. The other possibility here would be somebody that has such an incurable psychological problem that there's just no way in the world that anybody is ever going to fix whatever their psychological problem is. But the case law indicates over and over again that even those people that are trained to discern that can't do it on a very effective basis. To leave it up to a judge at a point in time where we're still dealing with a kid or somebody who has just barely become an adult doesn't make sense. When we have the very ability, the very process in place to determine those things at a point in time when the people who are going to determine them have the information they need in order to make that decision. And that would be the parole board.
Would we review, or should we review, the district court's application of the individualized Miller factors for abuse of discretion or de novo?
That's a tough one to answer. Initially, I would say de novo. And the reason is because Miller, if the Miller criteria is not applied to every single case, then what has happened is that that person who was a kid when they committed the crime has now still received, assuming they get life without parole, has still received an unconstitutional sentence. Now, if they were to apply every single thing that they were supposed to per Miller right down the line, then it would be for abuse of discretion.
Mostly constitutional issues are reviewed de novo, I think, by this court. Isn't
Yes.
that right? And this
That's
would be-
my
This
understanding.
would be a constitutional issue.
That's where I think it would start, yes.
What's the experience of other courts? Miller came down a few years ago. Parts of it are fairly opaque, and we're dealing with the question of what is rare. Can you help us with authority on the definition of rare, or what rare means in application?
I recall one case in particular from Indiana where the teenage kid killed his 10-year-old brother by bashing his head on a rock numerous times, then hiding the body, then going to his girlfriend's house and having a good time with his girlfriend, and later on laughing it up with his mother and eating popcorn. And that was one of those cases where they said, you know, that's over the line. You know,
If we look at how other states have reacted since Miller, am I correct? Massachusetts is the only one that's done the categorical ban on life without parole.
that's the only one I'm aware
And I
of.
think Indiana said no, Pennsylvania said no under their state constitution, and I think most recently Michigan said no, right?
Well, it's open under the federal constitution, the categorical challenge. And that's kind of a fallback position unless courts are able to apply Miller factors in a principled way. I mean, that's why you do categorical challenges. You do categorical challenges because we give up on the multi-factored approach, because we can't do it consistently.
And this one has got to be driving the district courts in this state nuts right now. I mean, the three opinions that I know of, this one being one of them, there was I think it's Bruriger, if I remember the name right, came out of Pottawatomie County, was actually here and got sent back. That judge did what I thought was the appropriate thing. He excised the unconstitutional portion of the sentencing statute and sentenced
Berger was an adult case, but
sentenced that kid to life with 25 years, no parole. Judge Bitter in Dubuque County just 2 weeks ago sentenced a kid to, or what, he's not a kid now, but he was at the time, to life with the possibility of parole with no minimum in place. You know, I think we're just all over the place right now.
Why isn't this one of the rare cases when it appears it was premeditated? He went over there intending to go after a guy he thought the guy he had beaten up with a brick, finds somebody asleep on a couch, shoots him. There's nothing impetuous. He's not in a fight. He's not in a crowd in a sudden situation. It's premeditated first-degree murder. Why can't the district court, after reviewing the Miller factors, do life without parole or no parole until 60 years?
Well, the description of the case itself is only one of the factors, of course. But in this case, you know, if we're talking about the factors of the case, what you just described is a run-of-the-mill murder. I mean, I hate to use that kind of, it sounds crass to use that kind of terminology, but that's a typical murder scenario.
All right, throw
saying-
in lack of remorse afterwards. Throw in a lack of acknowledgement of that what he did was wrong. Throw in a long juvenile criminal history without any successful rehabilitation before this first-degree murder. Throw in, you know, the rest of the factors. His behavior in prison, 10 major discipline violations, some involving violence, weapons.
It becomes a catch-22 because the things you're describing now also are the very things that are built into the fact that he's a child, built into those things that make him different from an adult, and are built into those things that are the very things that the U.S. Supreme Court said could change much more so than with an adult through rehabilitation.
And this gets back to my question earlier, Mr. Eastman. I mean, am I correct in understanding your position that even if the trial judge goes through all the steps that we outlined in Null and goes through everything that the U.S. Supreme Court outlined in Miller, and the court, in its considered judgment, says, I am sentencing this person to life without parole. It's your view that we should do an independent review of, what, heinousness?
Yes. That's exactly my opinion.
Well, it's an independent view of whether this is one of the rare cases to follow Justice Kagan's model. It has to be a rare case of life without possibility of parole in order to get life in prison. And that's why we're struggling around with what is rare.
Yeah, my definition, I guess the way I try to analyze what is rare, to me, there's got to be something more than just the murder. It was a murder that was coupled with extreme torture. It was a multiple murder. There was a torture and murder of a child. It was a murder that had to be done in order to make another murder work, or just something more than just a plain murder, because now we're talking about murders, hundreds of thousands of them that have ever occurred. That's not rare. I mean, granted, it was premeditated. All first-degree murders are. Granted, it was a hideous thing to do simply because no murder. I mean, there's no such thing as a nice murder. They don't exist. Thank you.
Thank you as well, Mr. Eastman. Ms. Link.
Good afternoon, Your Honors, Counsel, and may it please the Court. Today, this case presents the Court with a great opportunity to answer two of the questions that have lingered since Miller and Ragland were decided, and that is, first and foremost, whether this Court, under the Iowa Constitution, is going to adopt a categorical ban against life without parole for juveniles convicted of homicide, and if not, and I think more importantly, is how this Court views the appropriate application of Miller and Ragland by the district courts, and how this Court is going to review the inevitable challenges as we see today from the district court's application of the discretion that was invested in it by Miller and Ragland, and nevertheless the juvenile contesting that his sentence remains cruel and unusual. Now, in the first instance, the defendant has offered no principled basis to adopt a categorical ban here today.
Well, the principal basis is we don't want a totalitarian circumstances test that can't be effectively enforced by the court. Our obligation under Miller is to distinguish rare cases. And if we take the position that most first-degree murders are entitled to life without parole, we've, it seems to me, violated the dictate of Miller. We need to figure some criteria out, and that's part of the question you could tell. We need to figure out some workable criteria for what constitutes a rare case. If that can't be done, we end up in it seems to me, we end up in a categorical environment. So my invitation to you is to tell me what criteria, what kind of principle should we put on the issue of what's rare?
Certainly. So I think that your question poses several additional questions. First and foremost, I think Miller is giving courts discretion, and part of your concern about how we're going to address the issue of what is rare or uncommon under Miller seems to be more a question of whether there is going to be a problem in practice with courts applying discretion. Typically, we do have a presumption of regularity in courts once they've been invested with discretion.
For example, we have 38 cases. If 30 of them turn out to be rare cases with life in prison without parole, I think we have a problem. Do you agree?
I would agree that depending on the facts of those cases, I think that could present a problem, but that is a problem of practice, and it is a prospective one, because what I understand from the Department of Corrections is that only 13 of those 38 have been resentenced. So we don't know yet what the practice of district courts will be in assessing what is rare or uncommon.
And this seems to be the first one I've seen where it was resentenced to life without parole. A number have been resentenced to life with the possibility of parole. Is that right?
Yes, I think we've seen of the 13 a variety. I know we recently argued the case in Louisville, in which a court
and Justice Apple may disagree with my reading of Miller, but I don't read that Miller creates a constitutional right to life without parole being below some defined percentage. I think it's an observation by Justice Kagan that if you do what we are talking about in this opinion, that is apply the Miller factors, then it will be a rare situation when the juvenile offender ends up sentenced to life without parole. That's a possible reading, isn't it?
I agree, and that would certainly be the state's position. There's nothing in Miller to suggest that rare has become a constitutional rule of and in itself.
Well, it's not a percentage rule. I think that's absolutely right. But what the teaching of the cases is clearly, if you look at Graham, you look at Roper, you can't just rely on the fact that the crime is, quote, heinous, because all murders are heinous. There has to be some driving factors that allow the case to be characterized as one of the rare events. Your opposition suggests, well, I mean, rare means absolutely, I'm characterizing them, absolutely no possibility of rehabilitation or some kind of psycho problem that, you know, no one in the right mind would allow to be released. And that's what rare means. I mean, that's one threshold. What's your threshold for rare?
Well, I wouldn't say that I have a clear rule or threshold for rare. I think if we look at the cases that were actually before the Supreme Court, both in the Miller case as well as in Graham, and statistics looking at where the majority of juveniles serving life without parole sentences were, I think that the court in large part expected that because so many, I believe in 3 jurisdictions, were being sentenced to life without parole when they were 14 years old, when we're talking about felony murder, where it is not, although we often have a constructive idea of premeditated murder, it's not. You have individuals who had no intent, like Control Jackson.
In Miller, there was absolutely intent. I mean, he was pounding him with a baseball bat and saying he was God and whatever.
While he was under the influence of substances, Control Jackson, however, was a felony murder case where there wasn't even clear evidence that he was aware that lethal force would be used when he was operating people.
Can I shift gears for a second here? If Ragland can be read to say that the governor's commutation of 60 years wasn't proper. So wouldn't the situation in this case be that the court could have sentenced him to life in prison without parole, regardless of the commutation?
I believe, the state's position is, as we've argued before, that the 2 statutorily authorized sentences for a court right now until the legislature acts is life without parole or life with parole. I think it is clear from the record and the district court order here that because the commutation was not being directly challenged for them, that it was not their job to void.
But that would
an
not be a
otherwise valid
proper
commutation.
sentence under the state's position, as I understand it.
Sorry, can you?
That would not be a proper sentence under the state's position.
I would not agree with that here. I do not believe that we have an opinion that actually voids the exercise of the commutation power by the governor. And so I read this case to assume that if this court were to uphold the ability of the court to sentence Damian Seats to life without parole, that he would rather keep the commutation of 60 years and that there was no reason to void that.
But if the court is authorized to sentence someone with life in prison with parole only after 60 years, shouldn't the court be authorized in Lewisall to sentence somebody for 25 years? Because you're allowing them to pick something now. And it seems inconsistent to say you can only get life in prison with parole, life in prison without parole, but in this case, we'll let you pick something, but in Lewisall we won't. And the state's argued both cases.
I would disagree slightly with that characterization, only because in these cases where we have essentially motions to reconsider an existing sentence, that this court was simply recognizing that the sentence in existence was the commuted sentence and that it was affirming that sentence, not imposing a new sentence. If it had wanted to, the new sentence that it could have imposed was life with parole.
But again, it's the commuted sentence, a good sentence under Ragland. That's the question.
I believe the state's position is that it is.
What makes this the rare case? You could apply the Miller factors to the facts of this murder and this defendant.
Certainly. So going back to what we can glean from Miller and Ragland in those cases and how to apply this discretion, I think that what you have here, when you look at the 5 factors, which this court did here, I would have to disagree with opposing counsel that they did not examine all 5. And I think the comment about the attendant circumstances of his environment, rather than finding that it did not apply, was saying this was the one factor that applied, and the other 4 here were not demonstrated on the record. What you have is a 17-year-old, 7 months and I believe 21 days, year-old adult who demonstrated a clear, calculated, premeditated intent to kill someone. And he did so with the full recognition of the consequences. In fact, he did so because he had previously assaulted the man he thought he was going to kill with a brick, heard he was going to turn him into the police, did not want to go to prison for that, and thought his best bet was to kill him. So he entered the house in the middle of the night and shot a man sleeping 5 times. It turned out to be the wrong person. And so what we have in the first factor is the demonstration that the murder itself is not a product of reckless behavior, of impetuosity, of a failure to appreciate legal consequences. He was very much aware of them. And moreover, when we turn back to sort of the gang environment and peer pressure, certainly we are not contesting that the defendant was raised in an environment in which he was very much enmeshed in gangs and drugs, but there is nothing in this record to suggest that this crime was a product of that. In fact, I believe the evidence at trial was mostly that he was the ringleader and that many of his compatriots and accomplices tried to talk him out of it, and that he actually got them to drive him there and provide the gun.
Well, counsel, are you suggesting there's nothing in the record to suggest that because there's no expert testimony? I mean, isn't that something that the court can understand without expert testimony?
I'm sorry, could you clarify your...
You said there's nothing in the record to suggest that this crime was causally connected or the result of his impetuosity or his youth or his gang activity and the rest. I mean, do we need expert testimony to make that causal link?
I think that is part of the discretion that we entrust judges to apply, looking at the facts. And obviously, he was given the resentencing hearing and he could have put on evidence. We haven't argued about the nature or quality of that evidence. I'm sure he could have put on expert testimony if he wished. He did not in this case. But I think when you look at the circumstances, there's nothing here to suggest that, unlike, for example, a Contrell Jackson or an Evan Miller, that this was the product of being youthful or not really understanding what you were getting yourself into, or just being out with the guys and getting into a fight that gets out of control and somebody dies. This is a product of someone who very clearly thought through his action. There was a period of 2 weeks between the time he assaulted the person and decided to kill, and in fact did kill a second person. It was calculated, it was planned, it was designed to get around legal consequences.
Let me ask this question, though. You've repeatedly said discretion, discretion, discretion. And frankly, I don't know of a constitutional case where we haven't reviewed de novo. Maybe you can help me. But ordinarily, when we're applying constitutional law, we've reserved the right to review de novo with maybe some recognition of credibility findings and so forth. But can you help me on that issue?
So, I mean, I do think that in the wake of Miller and Ragland, we're operating a little bit in a no man's land of juvenile sentencing law.
There's no Iowa authority for review of a constitutional issue for abuse of discretion, I don't think. Now, correct me if I'm wrong, because I invite that because I want to probe my own thinking here.
I think this is an instance in which it depends on how you characterize the claim. If you're looking purely at what Miller requires, there's no challenge to its procedural requirements. There's just discretion and an argument with how that discretion was applied.
There's no Iowa constitutional case where we've reviewed for abuse of discretion.
I think this is one of the first cases that we've had a resentencing under Miller that has been posed with an ability to look at how we applied that particular discretion. Now, he has characterized it as an Eighth Amendment claim, which would, I agree, typically result in a de novo review because it's a constitutional claim. I think when we are talking about generally an Eighth Amendment law, when you have an individualized claim, we have a gross disproportionality analysis. And what I think we can do is take Miller and Ragland and the procedural protections there and the discretion employed and use that in the threshold analysis that any defendant bringing an individualized cruel and unusual punishment claim needs to pass before getting to a more thorough analysis. And I think absent some showing that the court has somehow not complied with Miller or Ragland, or that the record does not support how it applied the discretion, that the defendant is simply going to be unable to make that threshold inference of a grossly disproportionate sentence. Now, obviously, it's one of the questions the court will decide here today about how we will review these claims going forward, and one that certainly needs to be reviewed. But I think that there is something inherently concerning about, on one hand, this constitutional rule that is saying district courts need to apply discretion, but if appellate courts are going to review all of the facts de novo, then we are essentially turning them into resentencing
Could it be
courts.
possible to say, we'll review de novo to see if the district court actually considered all the Miller-Null factors?
Yes, and I think that perhaps that distinction between sort of those procedural requirements and then all of the facts.
But then, as to, the degree, the relative degree of heinousness of the crime, do we agree it's as heinous as it's in the 1% or 5% or 10% or whatever? That's not that rarity by that definition is not a constitutional requirement. We're not going to review for that.
Correct, the state would agree with that. And I think that that is demonstrated here, so that when we were looking at this here, there isn't a genuine question that the court here failed to comply with the dictates of Miller and Ragland in terms of what they considered, that they considered it on the record, that they understood that this was mitigating, and that life without parole should be an exceptional or rare instance. So here what we have is a question of how do we determine when a court is wrong about whether something is uncommon or rare? And I think where you have a clear, premeditated murder by a 17-year-old who is in fact the shooter, where he has demonstrated both prior to the offense and in the 5 or 6 years since the offense an inability and indeed unwillingness to be rehabilitated, that is the exceptional case that was foreseen by Miller. I see that my time is up, so I will ask this court to affirm the defendant's sentence. Thank you.
Thank you as well. Mr. Eastman.
Thank you. I'd like to go back to, I think, a question of Justice Appel's with regard to numbers. It strikes me that when all 38 of these individuals are finally sentenced, that's not going to be enough numbers to do some kind of a percentage analysis as to what rare is. I don't think that's a large enough number of people to make that determination. So the question being asked here then is, what is rare? And the question is, what's the...
I'm going to back up for just a second. I'm going to have you educate me a little bit on this. The whole idea, your first brief point is you want to have a categorical ban on any type of life without parole for any child, a person under 18 who commits what we'll call a Class A felony here. That's your position, correct?
It is.
And so then you're also using Miller as a basis for doing that, and again, kind of looking at Justice Appel's language about the rare case, and that's obviously in there, it's the rare case. But to me, just in answer to Justice Appel's questions, you gave me 2 or 3 or 4 of those rare examples where it might be appropriate to have a life without parole sentence for a juvenile. So why would I want to jump now and say under all circumstances under the Iowa Constitution that's cruel and unusual punishment, and there are no circumstances under which you can sentence a juvenile to life without parole under your categorical argument?
Because the determination of what is rare is going to be virtually impossible to get some kind of a consensus, in my opinion, because everything that is set out in the federal...
But how do we know? How do we know? You just gave me examples where you would have
I gave
a
you
rare
examples
example.
where... Yeah,
you gave me rare examples right here. So there obviously are rare examples and clear examples that you came up with yourself that tells me that why would I want a categorical ban then?
These are examples where the court has ruled. I'm not necessarily agreeing with the ruling. It's just examples of where they have made a decision, where a decision has been made. I think as time plays out here and more of these cases go before the court, you're going to find the decisions all over the place. In fact, I think we're already starting to see that by some of the examples that I gave. All the way from this case where we got life without parole to the case I cited in Dubuque County where it was life
And I
with
guess
parole in the minimum.
that's sort of my point, is that, this is going to have to be an evolutionary process of determining how we as a court, or how we try to advise our district courts about sentencing in these difficult cases. We're just starting along the path of trying to make those determinations. We started with Miller. We have these other cases that are coming along the pike, but I'm just dealing with your first brief point right now, because that's the one to me that's most critical. And then we haven't even talked about whether the 60 years is an appropriate one under our current jurisprudence. But don't you agree that, in this case, am I supposed to tell you that this is not that rare case, and these are the factors that we think of, and therefore, because this isn't a rare case, we're going to have a categorical ban on sentencing juveniles to life without parole?
No, that's not what I'm arguing. In fact, let me back up to the categorical ban and why I think that is so appropriate and necessary here. In reading the case law that led up to, and I've lost the name of the case, but the one that decided that it has to be rare in murder cases, I almost feel like I'm asking this court to follow the law, not change it, because all of the case law up to the point where we got to the I can't even think of the name now. But
Miller, you're talking Miller.
Miller,
Up
I'm
until
sorry.
Miller, yeah.
All the cases that led up to the point where we got to Miller demonstrate and show and talk about the differences between kids and adults. And those differences don't change because we're now talking about first-degree murder. Well, prior to getting to the first-degree murder cases, it was held to be cruel and unusual punishment to sentence those kids to life without the possibility of parole. That didn't change because we started talking about first-degree murder. They're still the same kids. They still go through the same crap growing up. And so for us to
Mr. Eastwood, I think you make a good point, and which leads to the whole predicate of what these cases are about, is that it's the science of the undeveloped mind, and that we all know by now that kids do stupid things, and you just shouldn't throw away the key and lock them up and throw away the key. But what about this case here, where some kids grow up faster than others, and they exhibit maturity levels that sometimes are beyond their years, just as they are below or right on. They're all over the board.
And the case law talks.
Aren't we relying on our district judges to go through this analysis and roll up the sleeves and do the hard job of judging and trying to identify? And in this case, we have a kid who did plan this crime out. He was told by others that he shouldn't do it. Aren't there things in this case that exhibit a mind that developed beyond his actual years, and that since he was in prison, he has turned his back to rehabilitation? Aren't there things in here that would support what the district judge did?
Certainly there are things that would support it. Absolutely. I can't argue that point.
If we don't have a categorical rule, then aren't we forced to rely upon the hard work of judging each individual case?
If you're talking about relying on the court in this particular case, obviously that's where you have to start. My argument being, though, in applying those criteria that are set out in the federal cases and in the state cases with regard to what to look at, the judge didn't complete the job. The judge started down that road. The judge did look at some of those things that you're talking about, just didn't finish. And without finishing, my client hasn't received the evidentiary hearing that he was entitled to.
Are you asking for a remand then?
I am, yes. I'm asking for a remand with directions. Actually, what I'm asking for is a categorical ban to life without parole for kids. But in the absence of that, I'm asking for a remand for reevaluation as to why, under all of the criteria,
I think that's your third argument then. You want a categorical argument, number one. Number two, you want it declared not rare. And number three, you want it sent back for further evidentiary development.
that's correct.
Thank you very much,
Thank you.
counsel. The case then is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.